Welcome, everyone, to the first episode of the AAA-ICDR Dispute Risk webinar series. I'm Thara Gopalan, Vice President of the American Arbitration Association and its international division, the International Center for Dispute Resolution. Since our founding nearly a century ago, the AAA-ICDR has been a leader in global dispute resolution, providing fair, efficient, and cost-effective solutions worldwide. As we approach our 100-year anniversary in 2026, and with over 550,000 cases resolved just last year, we remain committed to supporting Asia's dynamic dispute management landscape through our Asia Case Management Center in Singapore. Today's topic is one that's central to effective dispute resolution: risk management. I'm thrilled to have Jern-Fei Casey and Stephen Chan, both leading authorities in international arbitration and well known to all of you, as our panelists to share their valuable insights. I also want to thank our webinar series coordinators, Mitch Dearness and Cathryn, who've worked diligently to shape this program, and I'm very grateful to Omni, Bridgeway, and Aon for their support in bringing this to life. Today's webinar will begin with presentations from our series coordinators, Mitch and Cathryn, each sharing their insights on risk management in disputes. Following their presentations, we'll move into a panel discussion with Jern-Fei, Stephen, Mitch, and Cathryn, who will dive deeper into critical considerations for dispute risk management. Let's get started with Mitch's presentation.
Thank you very much, Thara, and thank you for everyone for joining today. Just bear with me as I bring up some slides here. Hopefully that's visible on everyone's screen. So as Thara mentioned, my name is Mitch Dearness and I'm an investment manager in Omni Bridgeway's Singapore office. I'm going to talk just a very little bit about Omni, and then I'm going to talk about how legal finance can be used to mitigate some key risks associated with disputes. So Omni is an Australian listed public company that's been around since 1986, and we've opened offices since then. We've been in Asia, in Singapore and Hong Kong since 2016. This slide highlights some key points. We have 3.3 billion Australian dollars of funds under management, 310 active investments, 407 completed investments, and over 200 specialists around the world. This map gives you a sense of our global coverage. You can see there the brown is jurisdictions in which we've funded claims. So it's quite a lot of experience there. Okay, so now I'm going to address the four key risks and explain how they can be mitigated or absolved completely through third-party funding. So the crux of third-party funding is that it's non-recourse finance, which means that the funder provides the costs associated with the dispute, and it only realizes a recovery if the dispute is successful. And by that we mean if amounts are recovered from the counterparty. If those amounts are not recovered, then the funder doesn't receive anything. So it's a great way to transfer that downside risk of loss. Now, most funding arrangements also cover adverse cost risk. So that is, if, for example, you start the arbitration and unfortunately you're unsuccessful, as all arbitration lawyers will know, often the tribunal will order that you have to pay the other party's costs. Funding arrangements can mitigate that downside risk of having to pay adverse costs or even security for costs if they're ordered throughout the life of the arbitration. Now, turning to the bottom left-hand corner of the slide is recoverability risk, and I think this is really key. No one likes to win a case, but ultimately they can't recover from the other third party, from the respondent. sorry. I mean, that's not really a good outcome. So third-party funding can be used to mitigate that recoverability risk. Firstly, some third-party funders like Omni have very extensive expertise in asset tracing. What that means is that at the outset, when we look at a case for investment, we will be looking carefully at recoverability and also the ways that we can help protect our investment by ensuring that those assets of the respondent are there at the end of the day. So we can mitigate the risk by providing that expertise. We also, again, mitigate the downside risk of a scenario where you've won, but ultimately you can't enforce or recover against the respondent, because then it's the funder who's paid for the dispute and paid for the recovery attempts, but ultimately they're unsuccessful. And then finally, financial risk, and again, I think this is sometimes overlooked. At the start of any dispute, companies budget for the dispute and they think about, how much is this going to cost? But what happens if it goes for longer than expected? That can have a serious impact on profitability of the company's profitability or cash flow. Or what happens if it goes over budget? These are all key risks that I think can be mitigated successfully through funding. So with that, I'll conclude my presentation and I'll hand over now to Cathryn.
Thanks very much, Mitch. Let me just share my screen. Please give me a moment. Could I just get confirmation from the AAA-ICDR team that you can see the presentation slides?
All good, Cathryn.
Thanks very much, Thara. So yes, hi everyone. Really lovely to meet you, and thank you for taking the time this afternoon to hear more about risk management. So my name is Cathryn Neo, and I'm an associate director. I lead the litigation and contingent risk offering within the Aon Transaction Solutions team. So essentially, an introduction of Aon. We are one of the largest brokers in the world, and our role as brokers is to represent the client's greatest interests, to work with insurers, which are insurance companies that provide various insurance solutions. So today, what really wanted to talk about and share is how that complements funding and how that can be used in the context for in a case that may potentially be funded or may not actually get funded, and why. So typical thinking of insurance for most people would be that I buy insurance when everything is well and good. So for instance, that would mean that if you think about it in your health insurance terms, you buy insurance when you're in clean bill of health, such that in the event you get a heart attack, you may be able to claim from it, for instance. However, today's discussion is going to be a bit counterintuitive to those who are more familiar with your unknown insurances. So examples of unknown insurances are like your directors and officers insurance policies, product liability policies, or public liability policies. These are policies where everything is well and good. When something happens, then you act to check if your insurance and if you can claim from it. But today we're going to talk about something a little bit different. We are going to be covering what happens if I have got nothing that I could claim on, but can I still get an insurance policy to assist in a dispute? So just very briefly, in a disputes life cycle, I'm sure a lot of you here in the audience are very familiar with a disputes life cycle. We're not going to go through it, but what exactly could you consider when a dispute happens? Can you still mitigate two biggest uncertainties in every dispute? The first uncertainty is duration uncertainty. You know a dispute has started, but you never know when it's going to end. More importantly, once a dispute has started, you cannot end it unless the other side agrees to end it, or for some other reason. If you're the claimant, you bring a stop to proceedings. But most of the time, you can't end it, and you can't really control the timelines because those are in the control of either the court or the tribunal. So the second uncertainty that we usually face as disputes lawyers would be financial uncertainty. And why is that so? financial uncertainty in two forms. First, in relation to the claim sum. Whether or not you're a claimant or defendant, the claim sum matters the most. Why? Because how much you're being claimed against and how much you are claiming against as well. And the second part being legal expenses, which are, we know, escalating, especially in arbitration. Legal costs could go as high as the amounts that are billed by the international law firms as well. So in situations like this, how do we navigate these uncertainties? So today we'll just briefly touch on just this slide where we look towards the four in the middle, the five actually, from stage 3 to 9 onwards, where if you're a defendant, you could consider what we have done is an adverse judgment insurance where it covers the amount and the claim sum that the defendant is being sued for. So in this case, if someone commences arbitration against you, suing you for 100 million, could you potentially insure that 100 million? Such that in the worst case scenario, when you lose in that arbitral proceedings, the insurer pays out that 100 million for you. And on the flip side, if you are representing the plaintiff or the claimant, and you receive an award that's very much in your favor, but guess what happens next? Respondents not happy, and they decide to then, well, try to set the award aside. And during these setting aside proceedings, it is very uncertain whether the award will be set aside. And even if it's not set aside in the first level, it may again be appealed. So duration uncertainty, financial uncertainty. And where we've been working with our clients on is judgment preservation insurance. So in arbitration and award terms, award preservation, where the award is essentially preserved such that in the worst case scenario, even if the award is being set aside, you actually get a payout from the insurer of the claim sum itself. Of course, these are always all subject to, insurer's appetite, the merits of the case, and what's, the amount that you're looking to insure. And the third one that I wanted to share as well is a little bit on what Mitch has talked about, adverse cost cover. So we actually work very closely with funders to ensure their adverse cost risks. Increasingly, we're seeing more and more clients taking this up in cases which are not funded as well. So after the event insurance, what it does really is it covers the adverse cost exposure such that when the tribunal orders that you have to pay X amount, of course, this is covered by the insurer. Increasingly, we've also seen after the event insurance also evolve to also cover your own costs as well. So that means it doesn't just mean the adverse cost you pay the other party, but your own solicitors and barristers' costs up to 70%. And finally, I'd like to touch on the last one being arbitral award default insurance. Arbitral award default insurance is the only insurance right now that covers recovery risks, which means that in a scenario where you've won an award against a state-owned entity and you may not be able to enforce it within 120 days, on the 121st day, insurer pays out the amount that you've won and subrogates the claim to take on enforcement proceedings for you. So we found that there's a lot more interest in this product, especially in the investor state space, because first of all, duration uncertainty, you're not sure even if you were to begin enforcement proceedings, how long those are going to take. And number two, there is certainty for the books as well in these insurances that allow the company, the corporation, to book in a certain amount of revenue from the awards that they have won. So before I conclude my presentation, most importantly, I think the most important takeaway today from this presentation is that there are known risk insurances, which I like to call heart attack insurances, being that you only procure it when you get a heart attack. The merits of the case is just like how we assess how severe that particular heart attack was and whether that can be covered. And the main point is it circumvents two biggest things: duration uncertainty and financial uncertainty for our clients, And finally, it provides cash flow benefits as well, with a certainty of an amount that can be claimed from insurers, allowing for balance sheet protection. Right. So I've come to the end of our presentation. I'm going to get out of this slideshow and pass it on to Thara, who will be moderating our very exciting panel.
Thanks so much, Cathryn and Mitch. I think that was a really nice introduction to some of the topics that we're going to be covering this afternoon. So for everyone in the audience, if you do have questions for our esteemed panel, please feel free to type your questions in the Q&A function, and we'll try and get to them in the course of the episode. But in the interim, my burning questions first. So Jern-Fei, for large cap companies, financial stability often suggests resilience against disputes. But beyond balance sheets, what hidden risks might they face in extended conflicts?
Well, firstly, Thara, thank you so much to you all for having me at this webinar. It's a pleasure to be able to join everyone in such distinguished company to discuss, obviously, managing financial risks. And the question that you posed to kick us off this afternoon is indeed one which is pertinent not just for large cap companies, but indeed for anyone who is involved in the dispute resolution process. Where you are faced with the prospect of extended conflicts, what I would suggest is that there are 5 different types of risks which you are potentially likely to encounter and would have to manage. The first 2 have already been referenced in your question, which is operational and reputational. And if I can take those in turn to begin with, operational risks are ones which, as they suggest, the fact that you've got an extended dispute resolution process that is yet to play out will have an impact on the operational aspects of a company's business, in the sense that they will take time away from relevant personnel who would have to devote sufficient time and resources to helping their external counsel and indeed in-house counsel manage a dispute, particularly one that is extensive or in an extended period of time in any event. The second one is reputational, because there is nothing worse than having to explain to investors what dispute or disputes you're embroiled in, and whether or not it has an impact on your bottom line, on your balance sheet, etc. So these are reputational risks that have to be managed. There are also more conventional reputational risks in the sense of PR aspects of a dispute, particularly those which are in the public domain. So again, that's a pressure point or a risk management point that a company, whether they are large cap or of any other size, will have to take into account. The third bucket of risks is really building on the operational factor, and is to deal with continuity of knowledge. Now, the premise of your question, Thara, was where there are extended conflicts, which by definition would mean that between the time when the dispute first erupted to the time when the dispute is resolved in the sense of a hearing and culminating in an award or a judgment, in particular in the run-up to the hearing itself, there is always a challenge in preserving within an institution continuity of knowledge of what had happened at the relevant time, and ensuring that you preserve the availability of factual witnesses who are able to give evidence on the material events when the time rolls around, if it ever rolls around, for the hearing to take place. The fourth risk is that, as with a lot of extended conflicts, it's never just one litigation, one piece of litigation. More often than not, in my experience, you will have ancillary, parallel, other litigation or arbitration being conducted in other jurisdictions. And that will obviously need to be coordinated on a global basis to ensure that you are running the same or at least consistent cases in all of the various jurisdictions where the litigation is playing out. And fifth, and some might say the most important one, particularly for those who are claimants or counterclaimants, is the risk of asset recovery. And it's very important to be able to identify from the outset, where you are in the position of a claimant or a counterclaimant, whether or not the other counterparty to the dispute has sufficient assets to meet an adverse award or judgment being brought against it. And that is obviously a risk that needs to be managed, and one that is, in a sense, a risk that trumps all of the others, because ultimately, at the end of the day, if the dispute does not culminate in any recoverable assets, it's not a dispute that would be regarded by the litigant, especially in the position of a claimant or counterclaimant, as being a meaningful dispute. So that would be my take on what are the basket of risks in the context of an extended conflict.
Thanks so much, Jern-Fei. I think that was really comprehensive on the 5 possible buckets of risks. So, Stephen, I think just looking at those 5 buckets from a comprehensive risk management perspective, what would an ideal early stage assessment of risks include?
Thanks, Thara. And thank you very much for inviting me to this webinar. Very happy to be presenting today. My name is Stephen Chan. I'm one of the international arbitration partners at Charles Russell Speechlys, based in Hong Kong. So with that very brief background, I think there's, in my mind, 2 buckets, essentially, in terms of the early risk detection or risk management. And one is more business, and the other is more legal oriented. And I think most clients come to us as lawyers to focus on the legal bits. But quite a lot of the time, the clients would be well served to consider their risk profile from a business perspective as well. And so the intro that we've had from Mitch and Cathryn, I think those are absolutely factors that in this day and age, where litigation funding is a lot more mature, and the insurance market and the products are also maturing, it would be remiss of lawyers to not look at those types of options for clients. And so it's very much a matter of risk appetite for the clients as well. Some of them are very, very risk adverse, in which case litigation funders are an absolute godsend, because they would be covering your entire downside, of course, with the consideration that they take a little bit on the back end. And then if you've got clients who are slightly risk adverse, but still want to have a bit of skin in the game, well, then the insurance products absolutely make sense. And from an economic perspective, sometimes can bring a greater reward for the client in exchange for that sort of skin in the game. So all of these factors are things that a comprehensive sort of risk management should take into account. Now, I would also be remiss if I didn't touch on the legal points as well. And I think the main legal aspect of this risk management is that a lot of clients focus far too much on liability. All the discussions are on why the other side, or if you're the respondent in an arbitration, why you are or are not liable for the claim, okay? And there seems to be less effort involved, at least in my part of the world, in terms of quantum, okay? And quantum, not only quantum of the claim, but also enforcement. And one of the best things that I think funders have done in the last decade or so is to enable lawyers and clients to consider enforcement risk, because it is part of the entire risk portfolio of that particular case. And so I think that is something that would form part of that early risk consideration. And just a bit more about quantum, because I think as soon as you start looking into quantum, what you'll find is that the nature of your case sometimes shifts. And I'll give an example of a case that I did quite some number of years ago, where there was a big dispute on a digital transformation project that went quite horribly wrong. And each side had their own theories as to liability. But in terms of the damages claimed, a lot of it was, it depended on how much time had been spent by the software engineers. And so immediately when you start looking at quantum, you'd start looking at the time recording that software engineers sort of punch in every day. And you'll often find that software engineers, unlike lawyers who are very granular in their time recording, they have no such concept. They'll punch in a bulk amount of time, 8 hours per day on bug fixing. And then you're trying to claim damages based on months and months of bug fixing without any particularities as to what the bug actually is. And so that only came out really further down the track. And I think an early comprehensive management, risk management assessment should look at that a little bit more. Hopefully that gives some flavor as to that question, Thara.
It's fantastic, Stephen. That's quite the war story. I think I just can't resist, Cathryn. I have to ask, because you're the insurer. So you've heard about Jern-Fei's 5 buckets, you've heard about Stephen talk about evidentiary risks as well as quantum risks. What are you seeing on the part of the insurer? What are some of the red flags that companies overlook in the initial stages?
Yeah, thanks, Thara. So maybe I'll just clarify as well. So Aon being the broker, we work with the insurers to procure quotes for the insurers, but we hear a lot of I wouldn't use the word complaints, I would use feedback from insurers, the underwriters sitting with the insurers on what are certain, all these risks that could possibly have been considered. So especially when we are looking at all these known risks, when we were assessing these known risk policies. First thing is, could they actually have procured unknown risk insurances even before anything had happened? So as part of an ongoing business review, some of these red flags are that companies just forget about certain insurance policies that may actually have helped them, which would allow them to claim defense costs as well. For example, your directors and officers policies, product liability, public liability policies. These are certain things, or even some construction risk policies as well. Construction risk policies, some of them allow you to claim for certain types of damages as well. So these are things where these may have been overlooked, or sometimes due to the lack of time, a project is ongoing at a very fast pace, they may have forgotten. So that's one. Another red flag that we typically see are the failure to account for legal costs. So we do see that parties, they get very bullish at the start. Everyone is I'm sure Stephen, Jern-Fei, and Mitch will agree with me that most of the time clients are very bullish about their case at the start. So they would say, yes, we have enough money for legal costs. But when it escalates, when they do not expect certain interim applications being made or certain injunctions being taken up, what happens next? They have to account for these legal costs, and then they come to the lawyer and say, what, you didn't tell me it's going to be way more expensive than I thought it was going to be. So that's where we also come in to help the client to see how we can mitigate and say, well, if the legal costs are escalating, how do we curb the downside risk of this escalating legal costs as well? And I think the third one, nothing to do with what I'm doing as a broker, but we do see this when we assess the particular legal risks in a claim. As a broker, we see that sometimes there's a lot of poor documentation, weak evidence, where a company, even though in their claim, they remain bullish and they say, no, we've got a strong case, don't worry. We don't see that. There's a lot of he said, she said. There's no documentation to support it, which could have been mitigated right early on when you start the project. And this would all go into the merits of the case, which essentially goes into where we see, would the merits be strong? If the merits are not that strong, you're unlikely to be able to get funding. or you're also unlikely to be able to get insurance on it as well.
Definitely bringing back nightmares, Cathryn, of starting new cases without any documentary evidence whatsoever. But okay, so Mitch, I think we've talked about duration, we've talked a little bit about liquidity. When you're managing duration and liquidity alongside case strength or merits, what overlooked factors should companies pay a little bit more attention to?
I think there's two that come to mind, or two I'll reference here. The first is that often what we see is that companies don't really forensically consider how the impact of paying for this dispute impacts their cash flow and their ability to fund their operations or invest back into the business. Because once that analysis is done in a considered way, it can often be the case that they'll consider perhaps that money could be spent elsewhere, and they'll turn to us, for example, to fund their dispute. So that's the first thing I think is often overlooked, and we help clients with that. The second thing, and it's not so financial related, but it just is a theme that's come up recently. It's the ongoing relationship with the counterparty. And I think that's particularly the case in relation to investment treaty cases or cases against states. So when we look at those types of cases, which we do often, I think a big point we have to discuss is, well, what's going to be the ongoing relationship here? Are you planning to exit the country or not? Because those things can not only impact the prospects of their dispute, but have very severe ramifications for them, but also certainly for our investment.
Thanks, Mitch. That's actually quite interesting, I think, about the investor-state type disputes and how that's shaping up slightly differently. Cathryn, so moving on slightly to post-dispute insurance. How is this evolving to cover risks once a dispute has already started? And crucially, what non-financial benefits does it offer?
Yeah, thanks, Thara. I think, first of all, a lot of these insurances cover the financial interests of the company. But what a lot of our clients don't realize is that it covers the duration as well. So, what I spoke of earlier, the two biggest concerns, duration uncertainty and financial uncertainty. What we were talking about just now in my presentation on judgment preservation, so award preservation insurance, which preserves the award once you've got a favorable award for you. But what it means is that doesn't mean that you have won the award, the other side is not going to try to set it aside in the seat court. If that happens, well, you may be assured that you have that financial ability from that award, but when are you ever going to collect on it? And will you even be able to collect on it if the award gets annulled? If it does, then you can't. So what it does is that while it's a financial benefit, it provides operational certainty. And why do I say that? Because it allows a lot of companies to book in a certain sum that they would receive, even if in the worst case scenario, the award gets set aside. So for instance, in $100 million, in one of the cases we're doing, I'll just give easier numbers to comprehend, because as a lawyer, my math is not that great. But so $100 million, and the award unfortunately gets set aside and to zero. That means that you are entitled to nothing. But what it means with an insurance policy would mean that out of the 100 million, you bear a small bit of retention, just like your car insurance. You have some skin in the game, say 10 million. The rest of the 90 million will still be paid out by the insurer. And what that means is that it ensures operational certainty as well, because you ensure that you have certain cash flow for your operations. Number two, reputational as well, especially for listed companies where they have to publish some of their, the amounts that they're exposed for in litigation or in disputes in their annual report as well. So this would then lead to, investor confidence in terms of the company's operations. So finally, yes, post-disputes, insurance is usually covered once the dispute's already started. There is certainty in terms of your total exposure in terms of your legal costs, because you can insure your own costs as well as your adverse costs as well. So that means that you no longer face a situation of escalating legal costs where the client is caught unaware when there are new things happening. It allows you to then book into your books what's the total exposure financially that you will face in this case. But of course, that's financial benefits. But a lot of these have to do with reputational benefits and operational benefits, because it always flows on to what the company has and how much cash flow they get at the end of the day.
That's really interesting, Cathryn. I think, one of the questions that we might want to pivot to, just looking at the front end of that topic, and I'll pose this to Jern-Fei. For companies that are assessing mid-dispute type insurance, what questions should they be asking to ensure that coverage aligns with both financial and operational needs?
Yes. Well, Thara, I think what companies should be asking are not just obviously in terms of what the ultimate end game might be, but what their intermediate needs might be in the context of the proceedings itself. So, for example, if you are a claimant and you are if you are a claimant and there is a prospect or indeed a likelihood of the respondent applying for security for costs against you, then in those circumstances, you would obviously need to consider the extent to which a funder and or insurer would be able to cover any order that is made pursuant for security for costs and or any adverse costs that might be awarded against you at the tail end of the process itself. So it's not just about trying to get you to a position where you can complete the dispute, whether it's arbitration or litigation, to the very end, but whether or not there are intervening needs that have to be fulfilled. There's another and perhaps a less discussed factor that is taken into consideration, especially agents who are perhaps blessed with a choice of two or more funders or different funding options, is you might want to consider the reputation, the experience of the funder and the insurer concerned, not necessarily in conducting the litigation or the arbitration, because that's really for the preserve of the litigants as well as their lawyers concerned. But I'm afraid I have to say that my experience of working with some funders and insurers are happier than others. There are those who, perhaps because they are bureaucratic in the way in which they manage their operations, or perhaps they don't necessarily have the same bench of experience dealing with litigation or arbitrations conducted in one part of the world as opposed to others, is they can end up being obstructive. And you end up spending a lot of time, for example, communicating with insurers or funders to that end. Now, so that's a factor which I'm afraid a lot of litigants who are seeking financial assistance often tend to overlook. And that, to my mind, is an important consideration. Because, of course, the focal point of a lot of our conversations thus far is what do the funders and insurers themselves look for? But I would suggest that equally as important is what exactly are the litigants themselves also looking for in the process, and who it is that they want to be working hand in hand with throughout what is going to be a protracted and at times stressful process.
Can I just jump in there, because something that Jern-Fei has just said has really resonated with me in my experience, also dealing with funders and insurers as well. And unless you're being paid by the hour, most clients would expect legal to help them navigate through the funder process or the insurer process, including getting opinions, answering questions, providing documents, providing assessments on merits, enforcement, quantum, all of that, to do essentially an end run on basically the entire case before the case even begins, right? And there is that is an inordinate amount of time that has to be spent doing that. And sometimes if that doesn't actually result in funding, and actually a lot of the time it doesn't, then that does tend to result in wasted time. So that is something that clients should be quite aware of right from the get-go.
Yes. Can I just add one very minor footnote to Stephen's observation, Thara? And it is he's focused obviously on the front end of the process in terms of the advice, etc., that some funders, in fact, all funders and insurers would typically require. I think there's also something to be said about getting an idea of what your funders and insurers expect the litigate. So let's say you've secured funding, you've got insurance in place, and the dispute then happens. I've been involved, I'm afraid, hopefully they're not on this webinar, but I've been involved in cases where, the sort of level or detail of reporting is so detailed, it gets to the point where, they're asking me, what did you have for breakfast? Did you have a burrito? What was in your burrito for breakfast? What are the pros and cons of, having a burrito as opposed to a fruit salad? And you end up, if I can use a football analogy, those of us who watch, for example, the English Premiership, you end up not just being the player on the field, you end up also have to commentate on the match. And, that is not a very efficient use of time, and it can lead to a lot of frustration.
I would just maybe make an observation as well about how funders usually go about their early stage assessment. It's true that some cases will come to funders and it will be just too early to form a view. And at that point, we either have to make a call. Is it worth an early investment in the case to pay for that initial due diligence or not? And that's ultimately a risk. And if it could be the case that we think the case has merit, or funder thinks the case has merit, getting their lawyers to perhaps do some more analysis might be the next step. But there are, of course, situations where clients don't have that money, but the case is promising, and of course we'll step in at that point and fund that early due diligence. So it's a question of assessing the risk and working out the investment, and if that's possible at that very early stage.
Maybe I'll just chip in from an insurance perspective as well. In terms of early case assessment, why there are questions being asked is because the insured, being the client, doesn't have to actually pay any money from the policy. And so they only pay it only when the policy is incepted. And so to ensure that they get the best bang for their buck, so to speak, they get the best level of premiums, and they get a certainty of coverage once it goes into underwriting. Because all of these insurances are known risks. It doesn't mean that, once you present a case, we give you a quote and then you can set the policy. There is also an underwriting phase where questions will be asked, just like how funders will ask the same questions. But what we try to do from a broker's perspective is to get these questions as much as we can upfront, so that the client is assured when they enter into underwriting and incur legal costs for this underwriting process, they are ensured that when it gets to the end of the process, there is an insurance there for them. We don't want a situation where we have seen, and that's not a good look for some insurers. If you promise a certain quote, and at the end of the day, I say 10%, the next, after underwriting, I say, sorry, it's too risky, I'll give you 50% premium. Nobody is going to buy that as well. So I think that's where there's a little bit of knowledge why a lot of questions are being asked at the start for case assessment. But at least for insurance perspective, clients are rest assured they don't actually have to pay any monies for the premiums. Of course, they have to pay for the lawyers, but if they don't have to pay for the premiums at that point as well. And also to the second point on the level of involvement from an insurer as well. Most of the time in all policies, the insurer, especially in litigation risk policies, insurer has no right of subrogation during the course of proceedings, which means that insurers actually take a back seat. They let the client run the show. Most importantly, there will usually be this clause that says that full strategic control remains with the client. Of course, there would have to be regular updates by way of email. It could be quarterly, just to update. Only when there is an important decision to be made, or when there's an important application, would you then alert the insurer, or in certain cases get the consent. But from our experience, insurers tend to take more of a back seat in the litigation process.
Mitch, I feel like you want to jump in there.
I think the idea for any funder, the ideal situation is just to not have to say anything, just to invest, and the case runs smoothly, which I'm sure it would if it was being handled by Jern-Fei and Stephen. And so, because from our perspective, we our job is not to manage cases. It's not our role. So I think that's the first observation. In terms of kind of perhaps a positive aspect of our due diligence process as well. Ultimately, what we have to do is we have to take our case to our investment committee, which is composed of former judges and quite well-regarded arbitrators. And I can think of countless examples now where their feedback has been quite helpful in structuring the way the case is handled. And as part of that as well, our enforcement team. So one key aspect which keeps coming up again and again is really how you structure your relief and how that goes towards enforcement, because in certain jurisdictions, certain types of relief, if ordered, are just unenforceable. So say, for example, a specific performance remedy or an award that ends up being ordered in a cryptocurrency as well. So I guess that's just a plug for the rigor that comes through the process and how it can be helped to frame the case.
Thanks so much, Mitch. Cathryn, I think we've heard you talk about percentages a little bit in a couple of your segments. And so I'm just going to throw this question from Sushil Shankar to you right now. What is the range of premiums to adverse or delayed claim ratios generally?
So I believe he's referring to adverse judgment insurance.
Yes.
That's for the is to protect the defense side if you're facing a certain amount of claims. First of all, the caveat, it's a lot harder to get adverse in judgment insurance as a defendant as compared to if you're a plaintiff, protecting an award. So that's first. The second is it doesn't apply to all claims. Of course, we're looking for cases where merits are at least 60 to 70% and above. And third, in terms of range of premiums, we are seeing that increase slightly from about 15 to 20% because of the claims environment right now. There are a few more cases where in the public where there are a few more litigation claims that are being claimed in globally amongst insurers, but that also means that the product actually works, because when a client has bought the insurance, of course, that's their aim. They will claim on it when they actually lose. So because of the higher claim environment, we are looking at a little bit higher premiums starting from 15%.
Thanks so much, Cathryn. So we heard from both Cathryn and Mitch, I think, as to slightly differing, but not quite so different considerations from the insurers and the funders. So Stephen, I want to ask from counsel's perspective, what insights can you share about the differing risk appetites of funders versus insurers? And how might that influence a company's strategic approach to disputes?
Yeah, that's a really good question. And before I answer that, I should say I come from a jurisdiction where until very recently, I would still go to jail if I was doing anything related to litigation funding. Champerty and maintenance are still live and well in Hong Kong for high court litigation, non-insolvency related matters. But for the last couple of years in Hong Kong, we've been able to do contingency fee arrangements and actually leverage off funders for that as well. And so when you mix, to me, when you mix funders and insurers together, that's almost absolute madness. And so people in my jurisdiction probably have less sort of experience in that. I'm lucky enough to know Cathryn from quite a few years ago. So I've had the benefit of her experience. But I think that the differing risk appetite, as far as I can tell, is mostly in terms of the quantum of claim. There are certain classes and a spectrum of cases where it is not economically feasible for a funder to get involved, all right? And so if we had to, and I'm sort of just pulling numbers here, and I could be completely wrong, but it seems to me that in sort of US dollar terms, 10 million and above appears to be quite a sweet spot for funders to get involved. anything under 10 million US, and you start to query whether it's economically feasible. And so there is this, in my view, a sort of gray zone, no man's land, where lawyers would look at the case and go, hey, this is still, 2-3 million US dollars, pretty good case, good merits, good enforcement, client still has no money, I can't go to a funder for this. And I think with the sort of advent of a lot of these creative insurance products, I think for the insurers, and Cathryn will correct me if I'm wrong, but the insurers might have more of an appetite in this band, simply because their premiums are calculated based upon the amount insured. So it really doesn't matter to them whether it's 20% of 3 million or 20% of 10 million, right? The risk appetite seems to be more suited or more aligned in that sort of space. But otherwise, if you're looking at sort of the 10 million US plus territory, the risk appetite seemed to be very high in both instances, of course, subject to merit and enforcement risk.
Well, maybe if I just jump in as well, Stephen, you're exactly right. The good thing with is that in insurance there are at least 20 over that we work with, and different insurers have different risk appetites in terms of the nature of cases as well as the quantum. Of course, when you have a very high quantum, one insurer may not be able to fulfill the entire risk as well. So what we do as brokers would be then we call that building a tower, where we find more than one insurer to be involved to quota share on the risk. Meaning it's $100 million claim, you may find one insurer giving 30 million, another one giving another 30 million, and then the subsequent one giving 40 million as well. And that's the benefit of being able to piece the puzzle together. And then when it comes to smaller claims, in fact, interestingly, this was a case where I thought it wouldn't be covered because the claim sum was $1 million. So, but we could actually find an insurer for $1 million claim sum, as long as the client is willing to pay the premiums. In that case, the premiums was about 10%. So the question really is whether you find the right fit and whether there's a merits of the case, because a lot of times, as long as the client's willing to pay sort of a minimum premium, we're looking at about 150,000. That minimum premium, there usually isn't an issue as long as there's an insurer willing to cover it.
Just one more thing that I'd add to that. I think for litigation funders, the sort of risk appetite is generally, at least from a solicitor's perspective, once in a blue moon, you will get one of those cases that are worth 10, 20, 30, 40 million US dollars or above. Jern-Fei might see these cases every second week. Us solicitors are less lucky to be able to have our hands on these types of cases. So the sort of a diversification of these cases with each funder is relatively rare. What I mean by that is even some big international firms would have 2 or 3 litigation funded cases going on at any point in time, but by and large it is quite rare. I think insurance offers slightly a different playing field, in the sense that because there is a sort of a lower amount, there is potential, and I'm seeing this at the moment with my own firm in the UK office, in our Middle Eastern offices, where there are cases being handled by the same insurer, for example. What then tends to happen is you get 2, 3, 4, 5 cases with the same insurer where it is geographically distributed. And at that point in time, my understanding, again, Cathryn, correct me if I'm wrong, but insurers start taking a more portfolio view of the risk appetite, as it were, right? So if you've got, 10 cases distributed all around the world with various premium structures in place, often you might find that the 11th case that you bring to them, the risk appetite for that is slightly higher, and there is more room for negotiation for premiums.
And
All
yes,
right.
just to add on to the point, yes, portfolio insurance is becoming more and more popular as well, so that you wrap a variety of cases in one basket. Yeah.
Thanks so much, Stephen, Cathryn. So Jern-Fei, I think just before we wrap up the webinar, we've got a whole range of products that are possibly available to us. How do we as a consumer navigate and evaluate the benefits of each option?
Thara, what I would suggest one does is that you have to consider, firstly, what are the jurisdictions, because there could be more than one in which any prospective litigation or arbitration will be conducted. Because bearing in mind, one of the 5 sort of risk buckets which I had identified in my answer to your very first question is the prospect that there could be related litigation or arbitration and other proceedings. So the first thing you want to do is you want to work out how you're going to stitch together a comprehensive funding or insurance package that will cover you in all of these jurisdictions. There could be, using a hypothetical example, there could be an arbitration seated in Hong Kong, but at the same time, it involves a conspiracy claim against, unlawful means conspiracy claim against a number of different entities which are litigated, say, in the Singapore courts. The company, which is the subject of the Hong Kong arbitration, could be incorporated in the BVI, and there could be company-related litigation in the BVI. For example, there could be an unfair prejudice petition if it's a suit that is brought by a minority shareholder. So one of the critical things to my mind that any client would need to take into account is the different jurisdiction or jurisdictions where any assistance, any financial assistance, whatever they may be, would cover. The second key factor to take into account, and this builds on, it was a joke on the part of Stephen, but there's a serious point there, which is where once you've identified which are the jurisdictions where you are or are likely to encounter a contested dispute, what are the rules in those jurisdictions about funding? And whether or not the funding package you are seeking to put together would be kosher in all of these jurisdictions. Because if it doesn't, then one of the things you might have to do is you might have to assemble a conglomeration of different financial products, some that cover some in some jurisdiction and others which cover you in other jurisdictions, where you've got to put this together. Unless it's conventional insurance, then you need to work out a sort of a globalized recovery scheme. In other words, who recovers and when, etc. So these are tricky questions, particularly with multi-jurisdictional disputes. I focus on them in my answer to your question because the ones which are what I call, well, there's no such thing as a plain vanilla dispute, but ones which are mono-jurisdictional, it's very obvious, there are no parallel litigation or arbitrations elsewhere, then putting together a funding package will not be as complicated. But the ones that will really test our mettle, which I've encountered before in the past and I'm still encountering, are the ones which are multi-jurisdictional in nature.
It's incredible, Jern-Fei. I think it's so interesting hearing from yourself and Stephen as to some of the complexities and the disputes that you're seeing already. Incredibly interesting for the institution to hear everything that's happening on the ground. So before we conclude today, we've got a couple of quick fire questions. So for each of you today, to take maybe 20 seconds to come up with an answer to these questions. And Jern-Fei, I'll let you take a bit of a break before we come to you. We'll move to Stephen first. Stephen, what's the biggest professional risk you've ever taken, and how did it shape your approach to disputes?
Really good question. And I think I'll sort of tie it back to what I was saying before about Hong Kong's development in terms of contingency fee arrangements, which have only just come into play a couple of years ago. I think the biggest risk I took personally was to actually enter into one of these arrangements, which up until then were not legal in Hong Kong. And so nobody in Hong Kong had actually done one. Thankfully, I had all of my UK colleagues who had been doing these CFA arrangements for years and years. But I think the way that it shaped my approach to disputes in general is to really look at it more on a holistic basis. Because if you're not charging by the hour and you're looking at the dynamics from a more contingent perspective, you start to see a lot more in terms of the merits, the quantum, the enforcement risks, and so forth. And that has to be all part of the contingency fee arrangement. And so we actually have our own CFA committee sitting in the UK, kind of like a funders committee would do before our firm would actually take these on. And so going through that process, even internally, actually really changed the way that I approach disputes generally.
Moving on to you, Mitch. If you could change one common practice in dispute resolution, what would it be and why?
If I can flip the question, I know I'm not allowed to do that, but if I can flip the question around a little bit, I would say, is there a common practice that is underutilized? And this is not intended to be a global comment. It's just an observation based on my experience moving into funding. And that is, I think, often mediation and settlement is underutilized. And countless cases come to us at the start, and we always ask, oh, have you tried to settle the case? And often the answer is no. So to me, that's always quite surprising. We've got into a stage where we're looking for funding, but the prospect of settlement hasn't been considered. So often what we try to encourage or have a dialogue about is perhaps including in our funding budget scope for mediation or at certain strategic junctures. And I've seen that work on countless cases where clients have had good outcomes.
Fantastic, Mitch. I love it. Appropriate dispute resolution. Cathryn, if you could only ask one question when assessing the potential risk of a project, what would it be?
Thanks, Thara. Usually I like to ask more than one question. I usually ask clients, law firms that I work with, Stephen would know that, that I'll ask more than 20 questions at a go. And that's very common. So to ask me to give just one question that, well, I would think the question, it rises from my mediation training from quite some time back when I was trying to get when I was getting the accreditation. So what is the best and worst outcome for each party? And because this will allow you to assess the financial implications for both sides, right? The best and worst outcome. And to in line with what Mitch has said, it also helps you to determine when what's the settlement figure that you're looking for and what's your motivation for settling as well. As we know, in a lot of cases, they actually settle even before they go to a hearing. So, yeah.
Fantastic, Cathryn. Very, very practical. I'm loving all of this talk about mediation. It's fantastic. Moving to something just ever so slightly more philosophical for Jern-Fei. If you could influence one policy or law, what would it be and why?
Well, actually, Thara, I think the answer to that question will be nothing. Why I would say it's nothing is because there are, apart from certain obvious areas which have already been dealt with from a legislative perspective. So, for example, third-party funding in Hong Kong, you've got the outcome-related fee structures in arbitration, or ORFSA, and you already have third-party funding allowed in certain contexts in Singapore litigation, as well as arbitration, of course. Other than that, I would change nothing, because one of the things which allow arbitration, I'm focusing on arbitration as opposed to litigation in this regard. One of the attractiveness of arbitration is that it is very laissez-faire. It evolves, it develops, it is conducted to meet the specific needs of each case. Now, true it is that you don't have a uniform way of approaching arbitrations, but I think that's actually a good thing rather than a bad thing. I don't think we all want to be sort of lining up and sort of marching like lemmings in the same way, because then that would rob arbitration of its ability to be nimble, to be agile in meeting the needs of the end users end of a particular case, depending on the specific facts and circumstances of each case. So I think the hopefully not too controversial answer to your question is I would change nothing.
Thank you, Jern-Fei. That's helpful. It leaves me to thank our panelists for an amazing and insightful discussion. Thank you so much, Jern-Fei and Stephen, for your time. Thank you, Mitch and Cathryn, for putting this lovely session together. And many thanks to Omni, Bridgeway, and Aon for your support of this series. Thank you, everybody, for joining us today. This is AAA-ICDR's Dispute Risk Management Series. We are based in Singapore at Maxwell Chambers Suites. Feel free to drop by anytime you're around. Thanks, everyone. Bye.
Thank you.
Thanks,
everyone.
everyone.
Thank you.
Bye.
Bye.